We're on the record, and this is Bell County Calls number turn 17,429. This is in the 27th Judicial District Court, Bell County, Texas. And this was originally in the interest of Jackson minor children. The court will note for the record that both the non-custodial and the custodial party present today, both with counsel and the state is present. So at this time, I'll go. My understanding is that there is a agreement on the majority of issues here today, but there is at least one left for the court to make a decision on. So I'll tell you what, let's go ahead and tell me what tell me what the disagreement is about, and then we'll figure out, then I'll let you call the record what the agreements are. Just in case it throws everything out of sort. So let's go ahead and find out what that is. Thank you.
Yes, Judge. So we've agreed on everything, what the child support should be, and the fact that the in line with the court ruling last time that the lump sum payments from 2020 should not be given credit. Mr. Williamson is, for final hearing, I believe, dropping that argument by agreement. So now the issue is just what are the arrears now, which there are none, depending on how the court rules, but none are very little. So for the months of October through January, there was no child support owed according to the state's Exhibit 2, which I guess I'll offer that into evidence.
Okay, let's go ahead. We'll finish with the opening. I can get this down. Thank you.
Okay. So in State's Exhibit 2, there is nothing due for the months of October through January. The reason for that is because the court temporarily abated his child support. But the court, since that time, corrected its prior ruling and determined that the abatement was actually not appropriate. And to my mind, that means the child support should have been due and owing during those months. I believe Mr. Williamson will argue that I waived the argument by signing the temp orders, but that was I was agreeing to it being reinstated right then and there. I wasn't agreeing to what should happen at final. So our signing that was just a temporary orders thing. It was not a final orders thing. Temporary orders are designed to give you some quick and dirty justice, right? Before you can have a full-throated dispute on everything, you got to get some things down just temporary. So at final orders, the court goes back and has the time to figure out if all of its choices were the right choices, with the perspective of all the facts. So now we're at final hearing. We can address whether what was done at temporary orders was appropriate. So those months should be due and owing. Now, technically, it should be the $654 a month, but I don't think that would be fair because I think the court would have lowered his child support monthly obligation if the abatement had not been done. So instead of the $654, I'm only asking for the $411 during the intervening period. If the court grants that and says that he owed the $411 for those 4 months, he will be paid ahead $9. So I would ask the court to order that he be paid ahead $9.
All right, then. Mr. Williamson.
Judge, the order that you made back in October abating the child support was de novoed up to the district court. The hearing was before Judge Jones because Judge Dusky was in jury trial. Judge Jones denied the de novo request and kept the orders in place. Mr. Hayden, on behalf of Ms. Seals, filed a motion in January to reinstate the child support. He did not ask to reinstate it back to October. He just asked the court to reinstate the child support. We had that hearing and you made an order reinstating that child support beginning February 1st of 2025. That hearing was not de novoed. That order was not de novoed. Nothing was sent over to district court to ask it. No, he did it wrong. It should have been back to October. There's nothing on file now asking you to go back and reinstate that back to October, so I would object to that not being a pleading on file and having already been heard, and not de novoed. So we would ask the court to deny that request and enter the order that everybody, the rest of the order that everybody's agreed on.
Yeah, okay, thank you. Mr. Welch.
Thank you, Your Honor. So the state, on that particular issue will defer to the court. I should note that, if we take, so Your Honor, I guess looking at the, the correct financial activity report without that, SSDI lump sum in there, as of April 9, 2025, Mr. Jackson is in future pay of $1,635, and that includes both, future pay of cash dental and future pay of cash of current child support. If we take the $411 that Mr. Hayden was asking for times 4, because that would be October, November, December, January, that'd be 1,644. So subtracting the 1,635 for future pay minus 1,644, he would actually be technically in arrears of $9. So, so Your Honor, like I said, state defers to you on that. That's it, Your Honor.
All right, thank you.
Yeah, I did the math wrong by $18.
Well,
Yeah.
$18 difference when we're dealing with this. It's not that bad.
Yeah, I mean,
all right, anything? Okay, now what? Okay,
I mean, just for ease, I'll say let's confirm at $0 if you go with my argument. That'll make everything easier. So to address Mr. Williamson's arguments, Your Honor, if I had de novoed on the issue of these intervening months in a temporary order, I mean, I think I would have been laughed out of court. That is such a small thing at temporary orders to be fighting over, when really that's something that should be addressed at final. I wasn't going to fight over when we have a pay record that is all kinds of crazy. I'm not going to fight over what the pay record should be at temp orders, right? Because the pay record wouldn't have really told me what I needed to know, because it included those payments from 2020, and it did take ages for the FinSpecs to get it corrected, because that's complicated. I think, I mean, arrears are such a complicated issue that really it should only be addressed at final, unless there is some just really important reason not to, because of the situation we're in today. So, yes, I didn't de novo that, because I mean, that would have been crazy. In my motion to reinstate, I was asking for temporary relief. I was not asking for permanent relief. I just wanted to get some support started, because Miss Seals was hurting for money. And if the court finds that he's paid ahead $1,635, well, her new child support is going to be, well, 300 something. I don't remember the exact number, but it's going to take 6 months or so before she starts getting money again. And that would be really harmful to the kids, for something that, for relief that the court granted, that now in final hearing, we have time to look at and see that relief was not appropriate at the time. I mean, at the time with what the court knew, fine, but now at final.
Here's the deal, sir. We don't stop the child support because of future pay. The child support still has to come in at the amount. The future pay really gets taken care of at the end of the cycle when the children emancipate. We don't stop because of future pay.
I mean, I've seen that work a few different ways. I've seen it work different ways.
Okay, but the bottom line is, yeah, we don't stop, because once you stop, it's hard to get reinstated. As I'm finding out, as far as this matter is concerned. I'll let you go ahead and wrap this one up, then, Mr. Hayden. Thank you, sir.
So even if it wouldn't create the temporary hardship for 6 months, it still would be inappropriate on the law. The abatement was not appropriate because it was a res judicata issue. The court had been apprised of the res judicata issue by Mr. Welch's brief at the time. So I would ask the court to find that he is in arrears for $0 and not paid ahead.
Judge, may I respond?
Yes, you may.
I understand Mr. Hayden's argument. I'm not saying he should have filed a de novo about what back pay arrears should have been. His de novo should have been about the start date of your reinstatement of the child support. And also I will remind the court, I know it's, understand their legal argument on whether it's res judicata, but she did get $18,000. So the argument of she's hurting now, she got $18,000 that Mr. Jackson's not getting credit for. So just out of, equity under a temporary order, I think you can do whatever you want under a temporary order because it's called a temporary order. You have a lot of discretion. So I would ask the court to take that into consideration on whether or not we backdate the reinstatement to October or keep it where you ordered already.
All right. Thank you.
Just briefly.
I don't think you should. Now, Mr. Hayden, no, I know what I'm looking at. All right.
All right.
So we're there.
I'll keep talking until you stop me.
I'm going to look it up because, but I know this has come up several times. We make mistakes. Judges make mistakes all the time, and we set things up on temporary orders, and then we go back and correct them. But I think once it's an order, it's the order until it's unless it's addressed one way or the other. And right now, I'm not sure if I can address it all the way back, Mr. Hayden. So I'm going to double check it. I hate that, but I got nothing to do this afternoon except pick up, go by the nursery and pick up my order for the flowers for the landscape stuff I ordered. So other than that, I'll look and see. But my overall feeling, sir, is that even though orders are not 100% correct, they are still orders at that time. Okay, and so that's when, and I'm going to confirm that one way or the other. But again, I haven't had to look at this for a while. It's not like I say I don't make mistakes more often than this, but yes, I hadn't had to go back and check it. So anyway, so I'm going to take that part under advisement and get y'all something out by Monday morning and via email because I got to come in this weekend also and do some other stuff. So this file will be sitting here on the top, and I'll confirm that one because this should be easy enough though. But I'm thinking, yeah. Well, even though it may be not been correct, once it's an order, it's an order. So anyway, anything else that's not in agreement, folks? I think he said everything else is in agreement. So let's get some. Do y'all want to prove that up with testimony with the parties at this time?
Sounds good to me, Your Honor.
Okay.
All right, dude. What you just want to play among the attorneys and let everybody sign off on it.
Well, I think we'll all sign off on it. I don't think we're going to dispute anything, but if you,
I've got enough testimony in this case. Okay. Yeah, we've got testimony, so I don't need anything further, but if y'all want to prove it up, that'll be fine. If y'all want to just circulate an approved order and everybody sign off on it, I'll take care of it that way. So Mr. Williamson, how do you want to do it, sir?
Judge, I'm fine. If you just want to make a ruling and we include that in the order that was already presented is good. Since this is abstract, I don't think we necessarily need testimony, but I think we all agree on what the current amount of support is. We agree on what Mr. Jackson's Social Security is and what Ms. Seal is receiving. So I think the only issue is whether or not the reinstatement went back to October or not. And if you make that ruling, the numbers will be updated. If you deny that ruling, it'll be what's already in there. So I'm fine if we just.
This isn't a case where I'm worried about locking people into the agreement. I think that's not an issue. Yeah. All
right. Well, good enough then. Well, I'll tell you what. If y'all want to do it that way, it look like I'll probably get the chance to get started on my research right now. Mr. Hayden, I see your lips moving, but nothing's coming through on audio for me, sir.
Oh, okay. You can't hear me?
Can you hear me now?
Okay.
It may have been delayed. It may have been delayed. I thought I thought that was you talking, and then all of a sudden I heard you, and then all of a sudden I could see your lips moving, and then I couldn't hear anything.
And I would like to have just 30 seconds of argument.
No.
Okay.
Hey, now I'm gonna look it up. All right. If I got discretion. If I don't, I don't. So
okay.
All right. Because if I have to, I have to. And then if I have my choice, then I'll make my own decision. Thank you. All right. Thank y'all both. Thank everybody very much. It's sorry to drag y'all out one more time, but I'll go ahead and let y'all prepare that order. And like I said, hopefully I'll get that to y'all by this evening, one way or the other. Thank you.
Thank you, Judge.
Everybody's free to go, and we're off the record. Thank you.
Thank you, Your Honor. And so Mr. Hayden, Mr. Williamson, I actually did prepare another version that's an agreed version of it as well. So when Judge gets back his ruling, I'll add it on there. Everyone signs, we submit.
Sounds great.
Sounds good.
Thank you, Your Honor. Thank you, Mr. Hayden and Mr. Williamson.
Thank you.
All right, yeah, thank you, everybody. And again, sorry for my mistake, and we'll get this taken care of. Thank you.
Y'all have a good weekend.
I've got a hearing. It's more of a, I think, ruling, legal arguments and then ruling. And Your Honor, this is the case that I submitted a research brief to you and the parties. Did that on Friday, I believe. And we did the special last, what was it? Last Monday, I think. I think it was last Monday. But both parties and me are here. See Mr.
All right, you said okay. Is this the one with the credit request, or is this another one?
Correct, Your Honor. This is the lump sum SSDI credit request, Your Honor.
And you said you sent over something in a summary or something that because I don't see it. You sent it to Belinda?
I sent it to Belinda, Your Honor. I sent it to DocuSign to Miss.
Okay. All right. I'll have her see about digging that one up. All right. Just a second. Let me see if I can find that. Thank you.
Thank you, Your Honor. Mr. Jackson, did you receive my research brief?
Yes, I did, sir.
All right, Mr. Welch, I found your brief, and I've read over it very rapidly. And while I'm in agreement with the circumstances that I had you research, sir, the problem the court is still having with this circumstance is that the final order that everybody, and it was based on the dad signing off on everything. I get it. The mother was in possession of information that, and I can't find it anywhere in the court files, that was made known to the court. Okay, so I'm not sure. I'm looking at whether or not this is an active omission that would extend the father's rights to get credit. But the bottom line is, mom got a large amount of money that was based on dad's disability, and the court needs to make a determination. And I think you're right on your res judicata, but the fact that the mom had that information at the time, she said she gave it to him or to the court, but he says he didn't. And I don't see anything in the court file that shows it was given. I'm sorry, she didn't give it to the court because I don't think we even had a hearing on it. So the bottom line is, I'm going to kick this for a day and let me finish the omission thing. But again, I think you're right on your res judicata. But as far as mom not giving the court that information or giving the state that information, that in the court's opinion may make that order avoidable. And as far as that's concerned, and I want to do my own research on that, sir. All right.
I understand, Your Honor. And I just I want to reiterate, Your Honor, that even if res judicata did not apply, and that the SSDI lump sum was there back in 2020, since he wasn't in arrears at that time either, and lump sums SSDI could only be used for credit for arrears and not for continuing child support obligations, it wouldn't apply anyway. I just wanted to make sure.
All right. Well, I'll go back over that the order. I mean, the financial activity report, and I'll confirm all that. And you're right. If he was in future pay then, or he was not behind anything, then I can't knock anything out. But again, it doesn't go for future pay. Only goes against the back pay, and the back pay. Yeah, well, it's kind of complicated, but yeah. So, but I'll agree with you on that also. But I'll go ahead and, like I said, let me double check what I'm thinking it is, and confirm all that, and I will, you don't have anything with me tomorrow, do you? I got a couple things tomorrow. Do you have any of those, either of those?
No, Your Honor, but I can appear when you want me to appear.
All right, who's got the?
I do, Your Honor. They're both mine.
Okay, then, well, let me tell you which one I want him to, you give him the Zoom code and he can appear on. And that's going to be let's make it the afternoon one. I'm sorry, I'm sorry, I'm in September now.
There's a 11 a.m., Your Honor, and a 3 o'clock p.m.
All right, let's do the 11 a.m., okay?
Your Honor,
Yes, ma'am.
may I say two things?
I'm gonna, ma'am, I'm on the
What?
record. What do you want to go ahead and say? Yes,
Okay,
ma'am.
one, it's about the credit. And Mr. Jackson also received a lump sum from the Social Security Administration when the
Yes, sir, I
children
know.
received their back pay.
Yes, sir, I know.
So that wasn't reported either by Mr.
Okay,
Jackson.
yes, sir. Okay, of course, we're aware of when the lump sum goes out, and not only the only reason the kids got a lump sum payment back was because dad got a lump sum back. I
Yes,
know that.
sir. Okay, okay. I just wanted to, and again, that was never reported either.
Okay,
And
yes,
then
ma'am.
the second thing is you're scheduling us to meet again tomorrow.
Oh,
Is that
ma'am, you don't have to show up. I'm just scheduling the lawyer to show up and I'll make a determination on whether or not the father's entitled to anything, because I didn't go over the entire financial activity report. I want to see when what the dates were and what he owed at that time, and whether or not he was entitled to credits at that time, which would probably put him in future pay now more than he is, but it's all determined, ma'am, of when when I give him, if I give him credit, when it was done, and whether or not there was anything that wasn't paid at that time or went unpaid at that time. So, no, ma'am,
Okay.
you don't have to show up tomorrow. Just the lawyer show up and confirm whether or not I'm gonna give the father the credit or any of the credit for the amount that was received by you from Social Security and lump sum.
okay? Thank you.
All right, so yeah, neither you nor Mr. Jackson have to show up.
Okay.
Any questions, Mr. Jackson?
Well, yes, sir. Your Honor,
Yes, sir.
I provided the Attorney General office with a case law which stated about future pays. If you can provide that with you, it would state that a judge provided the father with future pays, Your Honor.
I'm sorry, sir.
This case law that I provided to the OAG is in my discovery. It will show that a lawyer, I'm gonna say a judge.
Somebody else, this is secure. Sorry about that. All right, sir. We had somebody interfere. What was your comment, sir?
Sir, Your Honor, I took to the Temple office case law in reference to this matter. If Mr. Welch could provide you with that case law, it would assist me in.
What's the case, sir? What's the name? What's the case and what's the
It's a
site?
case in reference to SSDI being used for future pays, Your Honor.
What, sir? What's the case and what's the site? You remember that?
He has a copy of it, sir. I don't have it on my person now. It's in my discovery, Your Honor.
Mr. Welcher, you know what Mr. Jackson's talking about?
I think I do, Your Honor. I remember seeing something like that in our files. I can try to find it and submit it to you if you would like.
I'll see if it's I'll look at it and see if it's pertinent to what we're doing. Okay.
Thank you, Your Honor.
All right. Thank you.
So you
Sir,
going to
if you can, sir, if you can find the site, which is the case number and the case number and everything on it, forward that back to the state again, please. Thank you.
Thank you, Your Honor.
All right, but again, it's all about the math at the time, and we'll see. All right, thank you, guys, and I will again do the ruling on that when in the morning at 11 a.m. Now that you have to show up. Thank you.
Oh,
Thank you, Your Honor.
and Your
Thank you,
Honor,
Your Honor.
I just wanted to make sure because while the main issue, the main controversy is the SSDI lump sum, we were also just want to make sure we were also like planning on confirming dental and the health insurance and
I didn't think that. I thought that was agreed to. That wasn't an issue.
you already I didn't know you had ruled on it before, Your Honor.
No, I don't know if I did. I'm sorry, I don't remember. I've had a few cases since then.
Yeah, I didn't think you had ruled on it because we were.
All that was in agreement. Of course, I'll agree to. I got the current child support. I got all that written down. But the issue was the retro. So let's see. What amounts were you confirming, sir? And we'll see if I need to put this on the record.
Well, I know last time, Your Honor, I think we were all in agreement with Ms. Seal providing dental insurance at $30 and So Mr. Jackson would pay $30 monthly for cash dental starting September 1st, 2024. I think we were all in agreement with Mr. Jackson providing medical health insurance, $26.91. And you would receive a credit on that. And then, of course, the child support and the confirming of future pays, that's related to the SSDI lump sum there. But I just wanted to, I wasn't sure. I didn't think you had ruled on the dental or health. So that I just wanted to bring that up.
All right, folks, any of the dental and the current dental and health insurance things at issue, and y'all, anybody in disagreement with what the state just told the court at this point? Because that's what I wrote down, and I thought I wrote it down as an agreement, so I don't recall whether or not I said I was approving the agreement or just reset everything else for the day based and do that also. So is anybody in dispute with those two items?
No, Your Honor.
I do not, Your Honor.
All right, good enough there, Mr. Welch. At this time, I'll find that I did do that and find that that agreement is accepted. All right, not a problem. I wrote it down as such, so I'll put it down. I'll go forward with it as such.
Thank you,
All
Your
right,
Honor.
anything else, Mr. Welch?
No, Your Honor.
All right, thank you both thank y'all three of y'all very much. And like I said, folks, if y'all will be here tomorrow at 11, you can, Mr. Welch, send them the code just in case. But otherwise, you don't have to appear, and I'll double check everything against the pay record and the information I have. Everybody, you're free to go, and we're off the record.